Dear friends, a very good afternoon to all of you. Today I will discuss about the key points of Section 37. Earlier to this, we have discussed about Section 35, which is about the secrecy directions relating to the inventions relevant for defense purposes, and Section 36, which is about the secrecy directions to be periodically reviewed. Now, I will go to Section 37, which is about the consequences of secrecy directions, or in short, we can say the results or the outcomes of Section 35. Okay, as I always say, please keep the direct book with you while going through this video, which will be helpful to understand the contents of the video. Look, here also I have kept the direct in my table. Okay, so let us proceed now. Section 37 subsection 1 says, when the directions under section 35 are in force with respect to an application, the controller shall not pass an order refusing to grant the same, and not resisting any content of this act, no appeal shall lie from any order of the controller passed with respect to that. That means when section 35 is active, the controller shall not pass an order refusing to grant the same. That means the controller cannot refuse to grant a patent application. That means he has no power regarding this. He cannot refuse. Fine. Next, not resisting any content of this act, no appeal shall lie from any order of the controller passed with respect to thus. If in earlier times, if the controller has passed some orders with respect to the applications, no appeal can be filed against it. That means no one can appeal against the order passed by the controller before IPAB. What is IPAB? IPAB is Intellectual Property Appellate Board. That means we can say here in subsection 1 of section 37, some conditions lie as standby conditions, where the controller has no power regarding refusing a patent application, and if and whether he has passed some orders earlier, then no one can appeal against it. Okay, so we can say one thing, that if the directions under section 35 is active, a standby condition prevails for other proceedings. Okay, then the application may, subject to the directions, proceed up to the stage of the grant of the patent. That means the patent application can reach up to the stage of the grant of the patent, but the application and specification shall not be published and no patent shall be granted for the respective application. That means if and whether though the application has reached to the stage of grant of the patent, but still it has no power to be published or granted. Or we can say the publication and granting process will also lie in the standby condition, and so no publication or granting of an application is allowed. Okay, fine. Then next we will go to section 37 subsection 2. A complete specification is filed in pursuance of an application for a patent, and for it the directions from the controller has already been issued under section 35. Okay. Also we can say the condition found to be in order for grant. It has reached the stage of grant. We can say it has reached the stage of grant. Then below statements are valid. What are valid? When the directions are in force, any use of the invention is made by or on behalf of the order of the government, the provisions under section 100, 101 and 103 shall apply in relation to that use, as if the patent had had been granted for the invention. That means for satisfying the conditions of section 100, 101 and 103, the patent will be treated as it is already granted, or we can say patent will be treated as a granted patent. Okay. So what are section 100? Section 100 is about power of central government to use inventions for purposes of government. So he can use it whenever he wants. Section 101 is about the rights of third parties in respect of use of inventions for purposes of government. That means third parties are also allowed, but with the permission of central government. Section 103 says reference to High Court of disputes as to use for purposes of government. Okay. Next, the next part of section 37, subsection 2. If the central government feels that the applicant has suffered hardship due to the issued directions, it may pay him in form of solatium or compensation, having regard to the novelty and utility of the invention and the purpose for which it is designed, and so on. That means government here is not so hard. That means it also cares for the applicant, that if he or she has suffered so much in terms of time and money also, then what he will do? He will pay him. He will pay him or her in form of solatium or compensation. Okay. Then section 37, subsection 3. When a patent is granted which is given directions from the controller under section 35, same thing, when the section 35 is active, no renewal fee shall be payable in respect of any period during which the directions are in force. So there are no particular time span for which the application will be under section 35. So for any period, whatever may be the time span, he or she will not have to pay the renewal fee. We can say that this is in this way the central government cares for the inventor or the applicant. Okay. So that's all for the section 37. Okay. Please go through the video and also go through the Bare Act. Compare both, because I have given the explanations here only. So, and if at any point you are not clear, please ask me in the comment section, and if it is required, I will rectify also. Okay, so please share your compliments or comments in the comment section, and please subscribe my channel. Okay, thank you.